The beauty of physical evidence is that it tells a story. We look at the firearm, we look at the blood, there were cartridges left behind, projectiles were found within the toilet. Physical evidence cannot lie.
Yesterday, State Advocate Gerrie Nel brought the much-anticipated application for Oscar Pistorius to undergo mental observation in terms of the Criminal Procedure Act. Gerrie Nel cited some precedent-setting cases, as well as what might happen in the future if Oscar Pistorius appealed a possible sentence.
SCA mentioned that mental illness or mental defect are morbid disorders that are not capable of being diagnosed by a lay court without the guidance of expert psychiatric evidence. An inquiry into the mental state of an accused person that is embarked upon without such guidance is bound to be directionless and futile. Now, my lady, what we have is we have an indication of the defense saying, on our version, which we don't know which version was used, there is an indication that a psychiatric factor or psychiatric disorder may have played a role. If that is so, my lady, it's a matter to be referred for the court also to gain the views of experts that have a global view of the case and not only one version. At this stage, my lady, we say that certainly the court is entitled to know what the accused's defense is. With the fact that the accused has now furnished us with 3 versions.
Defense advocate Barry Roux objected, suggesting Gerrie Nel's reading of the law left much to be desired.
It says there must be substance in the allegations. You can't just allege it. In the Sandane case that the state relied on, this man was in Westkoppies. All those cases don't support the state. The state wants a second opinion through a very strange procedure. But let us look at the facts. Was there an allegation made supported by facts? The state accepts the expertise of Dr. Foster. She makes it plain and clear, and I've referred you to her evidence. She says he's not delusional and he's not paranoid. And it's just a ruse with respect in order to get a second opinion, and it's simply going nowhere. Where's the state's evidence?
Roux said the application was also premature because the defense's next witness would deal with the fight and flight vulnerability of someone with a disability.
That for the moment we must take emotions out of it, how many versions and whatever the address would be, and it's simply a case we talk, and that is what Dr. Foster is saying, and that's all she's saying to the court. When you look at the facts, you consider all the evidence.
Thank you. Thank you. Yes, Mr. Nel.
One thing I will agree with Mr. Roux, and that's that we should not be emotional. There I agree. I would also be as emotional if I called a witness and that witness left open the door for the referral of my client.
I'll be back with the decision tomorrow at 9:30.
That's a good business, mate.
Shortly after 10 o'clock today, Judge Masipa announced a decision on the state's application.
This court, as a lay court, is ill-equipped to deal with the issue raised in Dr. Foster's evidence at this stage. Dr. Foster's report, however, inclusive it may be, cannot replace a proper inquiry made in terms of the Act. A proper inquiry, which would be more comprehensive, would, inter alia, in my view, ensure that the accused gets a fair trial. Having regard to the above, I am satisfied that a case has been made out for the application or the relief as sought by the state, and I shall grant that order. I think it should be borne in mind that the aim of referrer is not to punish the accused twice. So if there is a possibility of making sure that he's an outpatient, that would, I think that would be preferable.
It will be investigated.
Yes. Thank you.
The actual order will only be granted next Tuesday, while administrative details are ironed out.